Good day, my name is Elena Sofia, and today my colleagues and I will be presenting the case of the Toshiba accounting scandal of 2015. Before we begin, allow me to ask one question. What happens when one of the most respected companies in the world prioritizes profit targets over transparency? That is exactly what happened at Toshiba. Founded in 1875, Toshiba was a symbol of Japan's industrial success, known for innovations such as laptops, MRI systems, microwave ovens, and DVD technology. Now, where did things go wrong? Following the 2008 global financial crisis, Toshiba faced increasing pressure to maintain strong financial results. Despite difficult business conditions, management continued to set ambitious profit targets. Between 2008 and 2015, Toshiba overstated its profits by approximately $1.22 billion. The turning point came in early 2015 when a whistleblower raised concerns about Toshiba's accounting practices. This triggered investigations and an independent review. The report found that the misconduct had lasted nearly 7 years across multiple business units. It also highlighted a corporate culture where employees felt unable to challenge senior management even when they knew something was wrong. The consequences were severe. In July 2015, CEO Hisao Tanaka and several senior executives resigned. Investor confidence collapsed, Toshiba's share price fell sharply, and the company suffered major financial and reputational damage. With that said, I will now pass the floor to my colleague, Ms. Anis.
Now, we will move on to the legal issues at its ratio this index. First, whether the Board of Directors' demand for unattainable profits targets breached their statutory duty of care. The Tokyo District Court found that between the year of 2008 and 2014, Toshiba overstated profits by approximately 152 billion yen over a 7 years period, driven by pressure from the board. This led to systematic accounting irregularities, especially in the commodities and video equipment sectors. The court further held that President Norio Sasaki and other executive personnel liable for failing their duty of care. They failed to post provisions for losses on infrastructure projects, pressuring subordinates into manipulations, and as a result, the executive were ordered to pay 300 million yen in damage. Second, whether the shareholders and investors have locus standi to sue Toshiba for false financial statements. The court firstly stated that locus standi means the right to bring legal actions. The shareholders suffered significant losses due to the fraud, which reduced their equity value. The court held that they do have standing to sue under Section 149 of the Japan Companies Act 2005 and allowing them to recover losses. Last but not least, Toshiba is liable for investor damages due to the gross negligence or malice. The court held that Toshiba is vicariously liable under Article 709 of the Japan Civil Code since directors and employees acted with gross negligence within their authority. The company's claim of protection under the business judgment rule was rejected as there was no evidence of good faith. Toshiba inflated profits by 224.8 billion yen, and the court ordered the company to pay 100 million yen to institutional investors. In conclusion, the Toshiba case highlights how board pressure for unrealistic targets can breach fiduciary duties and how companies bear liability for systemic misconduct.
Assalamualaikum and a very good day, Doctor. My name is Shafika Hidayah with matric number 300943, and I'll be handling application of legal issues under Malaysian law. Let's start with the first issue, which is the duty of care. In Japan, the court punished the former presidents because they pushed their staff with impossible profit targets, and then they totally ignored it when the staff started messing with the accounting books just to hit those numbers. If the exact thing happened in Malaysia, the director will be in huge trouble under Section 213, Subsection 2 of our Companies Act 2016. This rule basically says that directors must do their jobs with reasonable care and diligence. When our courts look at this, they check what a normal, reasonable director would have done in that same position. Therefore, top bosses like Norio Sasaki will not be able to just give the excuse that they didn't know what their staff was doing. Plus, here is the big difference. while Japan mostly treated it as a civil matter where the executive had to pay compensation. Meanwhile, in Malaysia, the Shin Section 213 is actually a criminal offence. They could go to jail for up to 5 years, face a fine of up 3 million ringgit, or even both. The second issue is about local standard. Basically, whether the shareholders actually have the right to sue. When Toshiba's fraud finally came to light, their stock price crashed and investors lost a massive amount of money. In Malaysia, if shareholders find themselves in a mess like this, they have two really solid legal paths. First, they can sue the company directly under Section 357 of the Capital Markets and Services Act 2007. This section gives investors an express right to compensation if they lost money because they trusted fake financial statements. The second way is under Section 347 of the Companies Act 2016, which is a statutory derivative action. Even though the general rule enforced against shareholders says only the company can sue for wrong done to it, Section 347 lets minority shareholders bypass the product board and sue the bad directors on behalf of the company itself. This forces those directors to pay damages right back into the company's account. Finally, let's talk about the business judgment rule and whether the company as a whole can be held responsible. The Japanese court completely rejected the director's attempt to use the business judgment rule because this funds cannot protect corporate officers when there is gross negligence or intentional fraud. Our Malaysian courts will look at this in the same exact way under Section 214 of the Companies Act 2016. For this defense to work in Malaysia, a director must prove that their decision was made in good faith and for a proper purpose. Since faking accounting records to hide massive losses is completely illegal, a Malaysian court would throw that defense out immediately. This brings up the question of whether the company itself can be blamed. Under Malaysian law, the identification doctrine applies because the executive board represents the directing mind of the company. Their fraudulent intentions are legally attributed to the corporation itself. Toshiba will not be allowed to hide behind its separate legal identity status. Instead, the company will be held primarily liable for the civil fraud and forced to pay massive damages to the defrauded investor. Therefore, that concludes my part, and the floor is now passed to the next counsel.
Hi, my name is Tanjai, matching number 297369, and I'm here to present the misconduct and contraventions committed by each party in this case. First, the main responsibility lies with the board of directors, especially the three top executive directors, which is Mr. Nashida, Mr. Sasaki, and Mr. Tanaka, who act as the mastermind of the company and this scandal. Three of them knew that profit challenge were unrealistic, and they also aware that the employees were engaging in improper accounting practice. However, instead of stopping the misconduct, they allow it and even approved the false financial statement to gain personal benefit. It has breached the sections 218 of the Company Act. Besides that, they also failed to act in best interest of the company and failed the duties stated under section 213 of the Company Act. They might face criminal liability under the Penal Code and also the civil liability as referred to the case of Transmile Group Berhad. Hence, even though the company has a separate legal entity, the director was still held liable. On to the audit committees that failed to perform its oversight roles has breached section 246 of the Company Act. In this case, although there was 5 members in the committees, there was only 1 member possessed accounting expertise. And that member has previously served as the CFO during the period of the scandal. This creates a clear conflict in interest and failed the function of audit committees as stated in the Chapter 15 of the Bursa Malaysia Main Market Listing Requirement. Therefore, the penalties will be given and the audit committees will face stricter punishment as referred in the case of Thrive Property Group Berhad. The internal audit divisions that responsible for providing independent assurance to the board has also breached their duty as the auditors under section 320 of the Company Act. Hence, the company is permissible to remove the auditors under section 277. In this case, there was a serious shortage of auditors combined with the top top-down culture. By that, the divisions and the auditors were ineffective and leading to the false expert statement breaching Section 167 of the Company Act. Finally, the external auditor, Ernst & Young Shinehongs. In Japan, the Financial Service Agency has imposed fines and suspended the firm from accepting new audit engagement for 3 months. The firm itself also resigned the CEO and pay cuts on employees involved. However, while applying Malaysia's law, punishments of pay cuts are subject to limitation under Section 24 of the Employment Act. In this case, the accountants have breached their duties and commit fraudulent practice. Hence, the firm may terminate the employment contract under the Employment Act. Even though in this case, the Toshiba did not bring any civil action to the firm still owed a duty of care to the company and should be liable on the legal consequences as stated in the case of Caparo Industrial vs. Stigmat. In conclusion, these Toshiba scandals were resulted from failures at multiple levels of corporate governance, including the board of directors, the executive directors, the audit committees, and the internal and external auditors. If this case assessed under Malaysian law, all these parties have their own liability and could face civil and even criminal liability for their misconduct. That's all from me, and I now pass to the next member. Thank you.
I will now present the recommendations and legal actions arising from the Toshiba accounting scandal, followed by the conclusion of this case study. Firstly, companies should focus on creating a more ethical corporate culture. The investigations revealed that employees were under significant pressure to achieve unrealistic profit targets set by senior management. As a result, many employees prioritize meeting management expectations rather than ensuring the accuracy of financial reporting. To address this issue, companies should promote values such as honesty, transparency, and accountability throughout the organization. Employees should also feel safe to raise concerns without fear of negative consequences. When ethical behavior is consistently encouraged and rewarded, the likelihood of corporate misconduct can be significantly reduced. Secondly, the whistleblower protection should be strengthened. In Toshiba's case, the accounting irregularities remained hidden for several years and were only exposed after concerns were raised internally. This highlights the importance of the role of employees in detecting wrongdoing at an early stage. Companies should establish a secure and confidential reporting channels and ensure that whistleblowers are protected from retaliation or discrimination. Strong whistleblower protection encourages employees to report concerns promptly, allowing organizations to address issues before they escalate. Thirdly, companies should also improve their risk management practices. The fact that Toshiba's accounting manipulation continued for almost 7 years suggests that warning signs were either properly or ignored. Organizations should regularly assess financial, operational and compliance risks and closely monitor business units that consistently report unusually strong results. Effective risk management should not be treated merely as a compliance requirement but should form part of the company's overall decision-making process. In addition, continuous corporate governance and ethics training should be provided to directors, executives, and employees. Such training helps individuals understand their responsibilities regarding ethical conduct, financial reporting, and regulatory compliance. It also reinforces professional standards and promotes a stronger culture of accountability within the organization. From a legal perspective, strong enforcement measures are equally important. Individuals who were directly involved in preparing, approving, or cancelling misleading financial statements should be truly investigated by the relevant authorities. Accountability should be extended not only to those who actively participated in the misconduct, but also to those who failed to exercise proper oversight. Furthermore, regulatory penalties should be proportionate to the seriousness of the wrongdoing. Besides financial penalties, sanctions such as director disqualification, suspension of professional licenses, and where appropriate, criminal prosecution should be imposed. These measures have ensured that corporate misconduct carries meaningful consequences and serves as an effective deterrent. In conclusion, the Toshiba accounting scandal illustrates how corporate misconduct can develop when the weaknesses in governance, leadership, and internal control systems are left unchecked. The scandal was not simply the result of individual wrongdoing but reflected broader failures across multiple levels of the organization. The case highlights the importance of strong corporate governance, effective oversight, audit accountability, and transparent financial reporting. It also demonstrates that legal compliance alone is insufficient without ethical leadership and a culture of integrity. In the Malaysian context, similar conduct would attract both civil and criminal liability under the Companies Act 2016 and Capital Markets and Services Act 2007, reflecting the importance of protecting investors and maintaining confidence in the capital market.